Matty was 16 when a car crash left him in a permanent vegetative state.
The surgeon said to my dad that night, he said, "I've saved your son's life and we don't know yet whether that was the right thing to do."
With her mum and her dad, Kathy looked after Matty at home for 7 years. Eventually, they decided to let him die.
There's a line in one of the reports written by someone who, who's a specialist who does this all the time, and he said, "Matthew Minton is the most severely brain-damaged person I've ever seen." And that was the level of his injury.
The family was subjected to months of inquiry, often intrusive, to get the final legal permission. Today, the Supreme Court would spare Kathy's family this last ordeal. A new ruling says that if families and doctors agree, food and water can be withdrawn without legal approval. There are thought to be some 24,000 people in a vegetative state in the UK. Some care can be withdrawn without legal permission, but to withdraw food and water, even if both the family of a patient and their doctor agree, it has become standard practice to apply to a court of protection to grant the order. This process can take months and be expensive. Now, the ruling means if a family and doctors both agree to stop support, they can do so without going to the courts. Some campaigners criticise the ruling.
They can effectively now be starved and dehydrated to death simply on the agreement by doctors and relatives that it's not in their best interest to go on living, and that can be done without any recourse to the court. We feel that is a retrograde step.
Removing the legal layer from the moment life support machines are switched off will concern some. But for this family, today's ruling would have made the agony swifter, even if no easier. Allegra Stratton, ITV News.
Ladies and gentlemen, persistent vegetative state (PVS), which also known as post-coma unresponsiveness (PCU), is a chronic disorder in which an individual with severe brain damage appears to be awake but shows no evidence of awareness of their surroundings. PVS describes patients who, after recovery of coma, return to a state of wakefulness without cognition. It is a form of eyes open permanent unconsciousness with loss of cognitive function and awareness of the environment, but preservation of sleep-wake cycles and vegetative function. The survival is indefinite with good nursing care, and the usual causes in order of frequency are nausea, metabolic, encephalitic coma, and also head trauma. An individual in a vegetative state may open their eyes, experience regular sleep-wake cycles, and exhibit basic reflexes, for example, blinking in response to loud noises, withdrawing their hand when it squeezes, and they also have a regulated heartbeat and can breathe without resistance. However, individuals in a persistent vegetative state will not able to follow an object with their eyes, respond to voices, or even show emotions. The vegetative state is considered persistent when it has lasted longer than 4 weeks. So a permanent vegetative state describes a vegetative state that has been present for 6 months if caused by a non-traumatic brain injury, or more than 12 months.
Judging from the circumstances of the case and the factors surrounding it, this court has referred to the Royal College of Physicians and the British Medical Association findings, where the importance of obtaining a precise and definitive diagnosis has reduced. They need to determine whether the patient was in a minimally conscious state or a persistent vegetative state to allow a withdrawal of nutrition and hydration. Assessing the patient's best interest through her current condition and her recovery is of greater importance. This court is also inclined to follow the previous decision I have made in the case of M against N by her litigation friends, the official solicitor and others in 2015, where a brief fact of the case is that M, the daughter of 68 years old Mrs. N, sought a declaration that continuing life-sustaining treatment via a percutaneous endoscopic gastrostomy PEG tube was not in Mrs. N's best interest. Mrs. N diagnosed with multiple sclerosis 23 years ago. In 2016, a consultant identified severe cognitive impairment, spasticity, incontinence, and epilepsy, and a PEG tube was placed in 2008, and by 2010, Mrs. N was quadriplegic. And by January 2015, M found her mother's situation intolerable, perceiving that no recognition or quality of life, and legal proceedings were initiated in April 2015, where it was decided that Mrs. N does lack capacity. The official solicitor, who initially presumed in favor of life continuation, changed position after reviewing the family's evidence, where it is no longer opposing the application. In that case, the main issue was a debate between the medical expert on whether Mrs. N is in a mentally conscious state or persistent vegetative state, and my decision in that case was as follows, where I am satisfied that Mrs. N would have found her circumstances to be profoundly humiliating, and she would want to avoid causing distress to her family. There is an innate dignity in the life of a human being who is being cared for well and who is free from pain. Their choice must be respected, as it is the essence of autonomy. It follows that those who not wish to live in this way must have their views respected too. I have decided that the patient was not in a persistent vegetative state. As explained, any bright line delineation between vegetative state and mentally conscious state is largely or perhaps even entirely artificial. It is also a common ground that Mrs. N had no opportunity to achieve any kind of rehabilitation or recovery, therefore the continuation of assisted nutrition and hydration is meaningless. The application was granted in respect of Mrs. N's dignity and freedom. From the case referred, the court heard sufficiently from her son's Tim and his brother Hugh to be clear that Mrs. Rushton would have hoped that her wishes in her advanced decision would have applied to her present situation. Her decision must be respected, and to act in her best interest following her son's evidence, she will want to be in a proper place to rest. Therefore, the application is granted and Mrs. R is to be placed in a hospice for her end of life in contemplation of the son Hugh request. This court is dismissed. Assalamualaikum and a very good evening to everyone watching this forum. So we are back today with another forum, but before we continue, I would like to introduce two of our guests. The first one is Professor Dr. Yasir, who has a PhD in comparative law, and another one is Mr. Rauf, who is a legal advisor for the Malaysian Medical Council. So now, the topic for today is quite a hot one, since it is a question that has been a lot Malaysian asked, which is withdrawing and withholding medical treatment, food and nutrition from persistent vegetative state patients. So today we are here with our guests in order to find out more about the laws for this matter, especially in other countries, and how it can be reformed in Malaysia. So the first question is to Professor Dr. Yasir, which is, based on your experience in your previous research, is there any country that has a law governing this specific topic, and maybe you can elaborate it further?
In starting, I will be using the case in United Kingdom, whereby there is a ruling, the case of Y 2018. The UK Supreme Court has confirmed that there is no general requirement for the courts in England and Wales to authorize the withdrawal of clinically assisted nutrition and hydration from patients with prolonged disorders of consciousness. However, in Hong Kong, there is a statutory that can be referred in, whereby it will be referred to the hospital authority, that it says it agrees that it is ethical and legally acceptable to withhold or withdraw life-sustaining treatment. Firstly, it must be mentally competent and properly informed patient refuses the life-sustaining treatment, and B, the treatment must be futile. So in determining the futility, firstly, futility can be viewed in a strict sense of physiologic futility, when clinical reasoning or experience suggests that a life-sustaining treatment is highly unlikely to achieve its purpose. And secondly, in most other clinical situations where futility is considered, the decision involves balancing the burdens and benefits of the treatment towards the patient. So in this case, no ethical difference between withholding and withdrawing. The Hospital Authority of Hong Kong concurs that there are no legal or necessary morally relevant differences between withholding and withdrawing treatment. Doctors who initiate life-sustaining treatment should be allowed to withdraw it when the treatment is futile. With this allowance, the doctor may initiate treatment with the benefit is uncertain and may consider withdrawing the treatment when no benefit is clearly demonstrated. This serves to safeguard those patients whose benefit from life-sustaining treatment may appear uncertain at first.
Okay, so that is really interesting, and there is a lot of new information that we can gain from Professor Dr. Yasir. So we have seen that there has been some similarities and differences between these countries in their laws. But however, since in Malaysia, our federal religion is Islam, and we are a Muslim-based country, so how does this law compare based on Islamic perspective, Dr. Yasir?
The CME acknowledges that effects of Malaysia's diverse cultural composition on local medical practice. Hence, it is in regards to end-of-life decisions in Malaysia must therefore be found in the Islamic Code of Medical and Health Ethics, in which Article 61 and 62 lay down the Islamic perspective on euthanasia and the approach taken towards termination of futile treatment and palliative sedation. So in this, the religious edict in which a fatwa have been issued at the 97 discourse of the National Fatwa Committee of Islamic Affairs in Malaysia, that adopted a similar position in reiterating the prohibition on active euthanasia and the permissibility of withdrawal of definitive treatment if the patient no longer has any hope or recovery, although this was expressly restricted to PVS patients. In this case, it fits in our scenario. Apart from the above, other religious directives properly addressing the ethics of end-of-life decision have yet to be contrived. And also, I would like to add on that are inevitable. So that would be on the Islamic perspective on withholding and withdrawing treatment for PVS patients.
Okay, thank you so much for that insight. I believe there is a lot of benefit that we can take from what Dr. Yasir has shared to us. And yeah, so now that we have got much information about laws in other countries, so we will go on to our second guest, Mr. Raouf. So what do you think of our current laws, and is it sufficient in Malaysia regarding withdrawing and withholding medical treatment in PVS patients? And what do you think that it can be done in order for us in Malaysia to reform our law in order to fill this hole? The floor is yours.
So thank you, Mr. Moderator. Before I begin talking about the reform in Malaysia, we need to know first what is the current legislation on this matter. In the context of Malaysia, the legality of withdrawing life-sustaining treatment, particularly on PVS patient, the doctor who made such decision to withdraw the treatment is protected by provision in the Penal Code and the Code of Medical Ethics, or called as CME. So basically, we can say that the Penal Code provides special defense, Section 81 and Section 92, that may invoke to protect doctors who act in the best of the interest of the patient itself. But there is ambiguity in how these provisions are interpreted, especially in the case where a patient's death is imminent and curative treatment is no longer possible for that kind of patient. So here, in terms of reform in Malaysia position, so what are lacking right now? Mr. Moderator, basically the intricacies of end-of-life decision making in Malaysia, particularly in the cases involving withdrawing and of treatment and termination station of PVS patient, underscore that the need comprehensive and reform. The existing legal framework, Section 81 and Section 92 of the Penal Code, offers some protection to doctor. However, there is ambiguity in interpretation, and the evolving landscape of medical ethics necessitate a thorough examination of current legal and ethical dilemma. First of all, Mr. Moderator, there is ambiguity of dilemma. The ambiguity surrounding interpretation of Section 81 and 92, as mentioned before, if we look closer, the challenge faced by doctor when making such a crucial decision to the patient itself. In cases where the aim shifts from preventing the death to ensuring the dignified end, the existing legal provision might not provide adequate guidance in this case. So there is a gap that need to be drafting more for the reform next. On the role of legislature itself, so basically there is a limitation of jurisdiction in addressing complex moral issue, underscore importance of legislation intervention. A legislative approach ensures a better representation of social perspective and allow for expert opinion to be considered on a more exclusive scale. Here, there is a problem in this matter. So, based on the ambiguity of the dilemma and the role of the legislature itself, so what recommendation that can be given to Malaysia itself in this matter? The first one is we need a clarity in legal provision, whereby we need to draft explicit legal provision that precisely address end-of-life decision, PVS, eliminating ambiguity and providing clear guidance for doctor in the current case. Secondly, on the ethical guideline integration, so here the integrate ethical codes and guidelines into the legal framework need to be done, ensuring harmonious alignment between ethical principle and legal provision. So the CME has been discussed previously, we need to make our own code on this matter, own guideline. And lastly, in terms of the authorities of case law, as we all know, Malaysia should make its own laws in matter regarding the decision in end life of a patient, especially rather than we only solely focus on outside law, such following the English law or the common law in this matter. Right. This is to ensure that a reformative and better law decision in a case regarding withdrawing and withholding medical treatment, food and nutrition for PVS patient can be better in the future of Malaysia. So, Mr. Moderator, that's the thing that I want to talk about the reform in Malaysia. So, that's all from me.
Well, thank you so much to both of our guests today. We have learned a lot and we have gathered so much information, and we have realized that there is a big lacuna in our law regarding this topic. So what we can do is that we can push the legislator to continue and fill in this lacuna and to make sure that our law in Malaysia is comprehensive. So that is all for the forum today. Thank you very much to everyone watching.